Breach of contract and defenses to breach are the next topic for our consideration. Let's think about what we had to do to get to this point. In order to reach the issue of breach, first we have to consider whether or not there is a contract. So we consider formation of the contract and we consider the defendant's defenses to formation. After that, we figure out exactly what the requirements of the contract are and to whom performance is owed. Next, we consider breach, and that's where we are now. Breach of contract. It's worth keeping in mind that there are three different levels of breach, and in a colloquial sense, we can think of them as being low, medium, and high. The more serious the breach by the defendant, the more remedies are available to the plaintiff. So, on the outline, you'll see that low, medium, and high translates into legal jargon, minor breach, material breach, and total breach. And we see that each level of breach is connected to a different remedy. Where we have a minor breach, the breaching party has substantially performed his or her obligations under the contract, but hasn't completely performed. The remedy, where there is a minor breach of contract, is the contract price minus any damages that are caused by the minor breach. And we've obviously got to look at facts to be able to figure out exactly how to translate this legal formula into a result. Once again, that's a good reason to practice. Next, we go up a level to material breach. We start off with a minor breach. The next step up is to a material breach. Here, the defendant has performed to some extent under the contract, but has done less than substantially performed. Again, these are just words to describe a relationship between the parties. You've got to look at the facts that are presented and determine in your own judgment whether or not the defendant has substantially performed. If there is substantial performance by the defendant, the most the plaintiff will be able to show is a minor breach. But if there is less than substantial performance, the plaintiff will be able to prove that the defendant is in material breach of the contract. And here, the plaintiff will be entitled to damages to make the plaintiff whole, and there will be a right to cure on the part of the defendant. However, the plaintiff does not have the right to declare the contract over. The plaintiff can't walk away when the defendant has materially breached. We've got to work out a relationship that will complete performance and that will make the plaintiff whole. Now, compare that to a situation where there's a total breach of contract. A total breach of contract is really most commonly tested in an anticipatory repudiation. That's where a party to a contract communicates to the other party, I ain't doing it. I won't perform under the contract. Where a party to a contract announces his or her unwillingness to live up to the terms of the agreement, that's a total breach by anticipatory repudiation. And keep in mind, there can be a total breach without an express repudiation. Suppose we've got a contractor agreement and the contractor takes all of his or her tools and equipment and workers away and stays away without any explanation. Well, abandoning an agreement also can amount to a total breach. So, as you practice, you will definitely encounter situations of anticipatory repudiation and contract abandonment. You'll also see fact patterns that add up to a total breach of contract that are slightly different than those situations that I have indicated. Where a party anticipatorially repudiates an agreement or walks away, the non-breaching party under those circumstances can declare the contract over. The non-breaching party can walk away and can sue in order to make himself or herself whole. And keep in mind, we're going to consider remedies in the subsequent video, but for our purposes right now, let's keep in mind that where we have a total breach of contract and the non-breaching party declares the contract over, the breaching party may still have a theory of liability. But that theory of liability would lie in restitution. It would not be a contract theory, because a willful breacher really doesn't have many rights under a contract. However, the breaching party in many jurisdictions, does have the right to prevent the unjust enrichment of the non-breaching party. This is one area of contract law where local rules really are different between the different states. A minority of states don't allow a willful breacher really to have any remedies, but that's a terribly small minority. The major rule is as I have explained it. Now, let's consider a few special issues related to breach. These are ideas that are particularly tested on the multi-state, but you'll see them on essay questions also. Remember that under common law, a plaintiff who has substantially performed but who has not performed perfectly is still entitled to sue under a contract theory. Next, a couple of UCC ideas. A UCC seller has got to tender the correct number of conforming goods, or the seller can reject the entire shipment without any liability, although, again, the seller does have the right to cure. Also, the UCC is at issue in some questions with regard to installment contracts. Suppose we've got a non-conforming shipment. A non-conforming shipment typically will not add up to a breach of the entire agreement unless there's something about the facts of the transaction that make this particular shipment a key shipment for the entire agreement. But typically under the UCC, a non-conforming shipment is not a breach of the entire agreement. Now, back to a couple of principles that apply both under the UCC and under the common law. Suppose we've got a situation where the contract itself is divisible, where the contract can be divided or split up into separate little sub-agreements. Under that situation, where a contract is divisible, the plaintiff can demand a recovery for an earlier shipment or an earlier section of a divisible agreement, even if the plaintiff is in breach of a subsequent part of a divisible contract. This issue of divisibility of agreements is relevant throughout the contracts questions that are presented, especially on the essays, but you'll see them on the MBE as well. Divisibility is an issue that is best practiced rather than studied. With regard to construction contracts, we know these are governed by the common law, and they are commonly tested. It is not uncommon for a construction contract to involve periodic payments. But the mere fact that a construction contract has periodic payments does not render the entire construction contract divisible. And remember that each party to an agreement has an implied obligation to help the other party obtain their objectives under the agreement. So that wraps up a quick consideration of breach, a very quick consideration. But go forth and practice. I think you'll find that the material that I have just explained here is plenty to get you started. You will undoubtedly realize that there are additional little fine line details. You may choose to annotate your outline with those details, or you may not. This is not a heavily tested area on the multi-state. On the essays, you'll see that these issues fit in sensibly with the other issues that are presented. Now, remember, as we consider contracts from above, looking down on all of the different issues that are presented, remember that the most common analytical mistake that people make is to become too plaintiff-centric and to not realize that the defendant can impose defenses at several different stages of the analysis. We know that a plaintiff in a contracts action has to establish a valid contract. And we know that a defendant frequently will offer defenses to the formation of an agreement. We've seen that a plaintiff has to show a breach of contract. And now we consider the issues that are presented by a defendant who wants to defend his or her actions. So we reach defenses to breach. There are three big ones and a couple of smaller ones. The biggest ones are impossibility, impracticability, and frustration of purpose. Those are the big defenses to breach. And here again, these are defenses that are going to be triggered by the facts. And in our work together, we'll take a look at a hypothetical or two that has good defenses to breach issues. So, let's consider the first big defense to breach, impossibility. Impossibility. Performance of a common law contract is excused by impossibility. when the subject matter of the contract is destroyed, or where a party to a services contract dies. Well, it's impossible to buy or sell a chattel if that chattel no longer exists. And it's impossible for a person who is contractually obligated to perform a service, it's impossible for that person to perform that service if he or she is dead. A pretty clear impossibility defense. But the trickier, and by far the more commonly tested issue, is impracticability. And I think of impracticability and frustration of purpose as being really aspects of the same basic nexus of facts. They're a little different. Impracticability and frustration of purpose are not identical, but they are quite similar and they are related to one another. First, let's consider impracticability. Under the UCC, impracticability will excuse performance where the goods are destroyed, or where performance becomes illegal, or where performance is prevented by some unforeseeable event. So, suppose we've got a lawful contract for the purchase and sale of widgets, and performance is due, let's say, in New Orleans, Louisiana. And shortly before performance is due, Hurricane Katrina arrives, destroys a lot of New Orleans, but doesn't destroy the subject matter of the agreement. Is it necessarily impossible for the parties to perform? Answer, no. But under the circumstances presented, is it impractical for them to do so? Certainly, we could all come up with a fact scenario in which the answer to that question would be yes. Frustration of purpose is a little different from impracticability. Frustration of purpose is the defense to breach where the relationship between the parties really hasn't changed, but externalities in the world have changed in such a fashion as to make the contract really irrelevant to the real needs of the parties. Again, it's not very wise to spend much time studying this material in the abstract. It is fairly commonly tested, but as you study the way this material is tested, you'll begin to see quite quickly that it's tested in strikingly similar ways over and over again. Next, another couple of little tertiary defenses to breach. First, modification or a novation, where an original contract has been modified by the parties or where the parties have junked their original agreement and entered into a novation. The earlier terms no longer apply, and although a plaintiff may well try to sue under the terms of the earlier agreement, if there's been a modification or a novation, the original terms have been essentially written out of existence, and the plaintiff will have a much harder time to make his or her claim. Also, where a party's duties are discharged for one reason or another, discharged by something other than performance, again, the plaintiff will have a great deal of difficulty establishing a breach of contract. Well, that wraps up about as concise a discussion of breach and defenses to breach as you're likely to hear. I think you'll agree, though, as you get into practice, that although this is a very abbreviated discussion, it's a surprisingly complete one. I think you've probably got just about all you need to go practice, and then you'll identify a couple of little areas where probably you need to know a little bit more. Well, we've done a lot of the legwork in contracts at this point. We've considered formation, defenses to formation, the terms and the rights of non-contracting parties, breach, and defenses to breach. Next, we will consider remedies, and then after that, we will have a few separate ideas that deal with the law of sales.